Welcome to Self-Represented in Family Court, the only podcast you need if you're feeling lost, stuck, or overwhelmed in family court. At Self-Represented, we don't waste time discussing the law like all the other podcasts. We focus on what really matters in your divorce or custody case. That's strategy. With your host, Tracey Bee, former family law attorney turned pro se family court strategist.
Have you been classified in family court? I mean, do you know if your judge gave you a label? How about the key players? Have they already tagged you before you started telling your side? There's a strong possibility that yes, you've been labeled, you've been tagged, you've been classified by the court. I'm going to do a deep dive into that topic today. Hello there. You're listening to another episode of Self-Represented in Family Court. And I'm your host, Tracey Bee. Today I wanted to talk to you about the possibility, the likelihood of the judge, guardian ad litems, lawyers, and other key players labeling you. Yes, labeling you, relegating you to a specific title by pattern, by behaviors. The list goes on. Yeah, it happens. Judges, other court key players, they actually watch you, listen to you, and then they label you, they classify you. Why do they do that? There's several reasons. But I want to talk to you and explain to you something. Family court is a mill. It's a circus. It's a zoo. It's a mill. I hate to put it to you that way, but that's the reality. You'd like to think that you are one of a kind, you're different, your case facts are different, you have highly sensitive issues that separates you or distinguishes you from the litigant that was right before you in court. But from the court's perspective, you're just a number. Yeah, you're just another litigant. Yes, you're a litigant. When you walk into a courtroom, you are no longer a parent or a spouse or soon-to-be ex-spouse or ex-partner. You are a litigant. That's what you are. And they label you based on that. They do it because it's a mill. It's easier to classify you because then they'll know how to handle you and your case. And it's important to know this, not just know it, but to accept it, because it's going to help you influence the outcome, not just the outcome. It's going to help you influence the progress, the experience, the journey of your case. If you can somehow figure out exactly who the judge sees. So let's talk about why. Why do judges classify litigants? Well, as I mentioned, family court is a mill. Judges see hundreds, if not thousands of cases daily, definitely weekly, and sometimes monthly. So they're not going to remember every detail about you or your case or your children. They're not going to remember that every time you approach them or you're in their courtroom. So it's easier if they classify you. And sometimes they may go as far as to notate your file, your court file, to remind them of which classification you fit. That may be a bit extreme, but they may do it mentally. There may be some insider coding system they use where they can actually, whether it be mentally or, practically, where they actually label you. It makes things run a lot smoother, a lot faster, and it gives them the impression that they're a lot more professional and efficient than they are. It reduces cognitive load. They don't have to think as much. I don't know about you, but I've noticed when I go to family court that a lot of judges just really don't want to think much. And I get it. It's not an easy job to hear emotional testimony and scenarios all day long. It's not an easy thing to do. And so whatever they need to do to make that job run smoother, where they're not burned out so fast and so easily, then that's probably, it makes sense that they would actually label you, give you a classification, an identity of sorts. They look at patterns, they look at your narratives, they watch behaviors, and believe it or not, as I mentioned, judges don't remember you, every time you go to court. They don't remember the details, the background. They don't remember that. They do take notes. Some judges take better notes than others. Some have better memories than others. Some just need a trigger and they remember, or they may recall. But the reality is, you're a number. It's a mill. You're a number. And if it makes things easier for them to watch patterns and hear narratives, then again, it's not if it makes things easier. A lot of times it does make things easier. So that's what they're going to do. That's what they're going to rely on. And understandably, I get it. Let's talk about the actual common but unspoken categories that they do label you. What do they call you? What label did they slap on your file? Let's talk about those. You know what I want you to do? I want you to listen intently, and I want to see if you can self-identify which category, which label you fall under. The reactive litigant. The litigant that stands in the courtroom, and every time the opposing party or the opposing counsel says something that's not necessarily accurate, not true, not correct, they react. They speak out, they grimace, they shift their body. They can't hold it. They have to react. They have to respond. They have to let the judge know immediately, instantly, that what the other party or opposing counsel is saying or doing is not correct. It's not appropriate. It's not the way things happen. Is that you? How about the emotionally flooded litigant? The litigant who can't seem to tell a story or tell a narrative without infusing a lot of emotion into the story, into the narrating. Whether it be crying or the raising of the voice or the lowering of the voice or the quivering or the eye rolling or the shifting, the one who's emotionally involved to a fault. Whether they're telling their story or just listening, they're wrought with emotion. Is that you? How about the disorganized litigant? The one who will tell a story and has no dates, no notes, no video, no text, no emails, no proof at all. They are the I don't recall, or I think, or if I can find it, or I'll look for it. Is that you? I certainly hope not. A disorganized litigant is not given much credibility. So hopefully that is not you. How about the overconfident but unfocused litigant? We all know who that is. The overconfident, but they're not focused. They're all over the place. They're scattered, but they're so overly confident. Sounds familiar? Yeah, I see that a lot. I'm sure you do too. Hopefully that is not you. And then there's the prepared, organized litigant who has everything labeled, identified, who has dates, times, locations, witnesses, who is real concise, who has tell the facts the way they're supposed to be told without all the emotional nuances involved or added. They are the ones who are really good at telling their side of the story from a neutral, objective perspective, and the judge believes them. The judge loves them. Is that you? Or how about the one who is emotionally mastered and not necessarily prepared, but they have mastered their emotion? They learn to be quiet while the other party is talking or the opposing counsel is talking. They learn to listen to the judge and pay attention to the judge because they mastered their emotions and their mental acuity is on 10. They're sharp. Maybe that's you. Well, the judge loves you if you're the latter too. The reactive or the emotional litigant, probably not. And so if the judge has labeled you as either of those, and you know this, then it's advisable that you, when you're in front of them, if you can figure out the labels that they've given you, if you can identify how they've classified you, it's easier for you to prepare, present, and position your case. Makes sense? Yeah, because now you get to tailor your facts or your story around how they see you, the label. And it's easier than randomly assuming a title or assuming a perception or perspective of the judge about you than it is to understand they usually have a list of typical labels, classifications that they use for most litigants. Okay, let's get right into it. As I said, courts are a mill. They're overloaded, judges are overwhelmed, the process gets complex and unnecessarily delayed and stalled. The key players are inundated. I mean, there's a confluence of things that's going to affect the way your case proceeds through family court. And there's no denying that's your case, that's the person next to you, that's the person before you and after you. That's just the nature of family court. So, classifying you. Let's start with why they do this. Judges see hundreds of cases per day. Per day. Maybe not so much in the rural areas, but typically in the suburban and definitely the city, the urban areas. The cases, the daily dockets, as they refer to, are overloaded. They have several cases, and a lot of them they see you as a number. So they're not remembering every detail or every fact or every background of your case every time you go before them. It's just humanly impossible to do that. So what do? They do what I do as a business owner. They create systems. They create an automation, a workflow. And part of that workflow or that automation is them seeing you and every other litigant that comes before them. So now that you know why, you know the classifications or the labels, now is the time to understand how they affect outcomes. You're in court, whether you were the one who started the case or you were the one being sued and forced to show up in family court for your case. You're in court and you want an outcome. You want the outcome that you initiated or that you requested, or you're fighting against an outcome that the other party who initiated the case. Either way, it's still an outcome you want. You have a desired result, end result. Therefore, you should take the initiative. You should take the active role you should take it seriously when the judge and or the key players classify you, because it will most certainly have an impact on the outcome of your case. Never mind how the case proceeds and progresses through court. Everything the judge notices, witnesses, perceives, identifies, classifies, everything the judge specifically, every conclusion or observation, every pattern, every behavior the judge actually gives attention to is going to affect not just the outcome, but the experience, the journey, the way your case proceeds through their courtroom. And so you need to understand that everything from the judge's perspective, court is not about the other party. It's not about opposing counsel. It's not even about your high-priced, reputable attorney that you have. It's about the judge. At the end of the day, the judge has the authority to make the decisions. And whether it's procedural or substantive, whether it's minor or significant, whether it's temporary or final, those decisions, those rulings the judges make is going to have an impact on your case today, tomorrow, next year, in the next 5 years. And so the classification is no different. So how it affects your outcome, how much patience a court gives you, how much attention a court gives you, and your position, the way you present, the way you show up, is significant. It's important. You need to be mindful of that, because if the judge doesn't find you credible or believable, even likable to some extent, then again, the way your case moves along in court is going to be affected by that. There's no doubt about that. The judge's labeling of you or classification of you is going to determine how much credence they give your documents you submit, your motions, your petitions, the exhibits you attach to them, even your briefs if you have any to file. The judge is going to maybe spend 5 minutes, maybe take the time to read it more, because if you are that emotional, reactive litigant who the judge sees, a 20, 30-page motion, they're probably going to think this document is full of emotions. You got it. As opposed to you being this poised, credible, prepared litigant that they've classified you as such. The judge's clientele will think, a 20-page document, this must be really pithy, really significant. I'm going to take the time and not necessarily read every page, but I'm going to take the time to peruse every single page to get an idea of where they're coming from. And then how much leeway you get procedurally. The judges in family court have a lot of discretion, They get to decide directly and or indirectly how your case moves along with the decisions that they make, even to not just on the law, but on procedure. And even though procedure is a little more, it's a little trickier to deviate from procedure, the way the judge applies the exceptions or the workarounds to procedure is the problem, is the issue that you'll come across. So if your judge classifies you, again, as the confident, overly cocky litigant, the judge may not give you a pass, especially as pro se, especially self-represented. When you're self-represented, you want the judge to give you a little bit more leeway when it comes to procedure. Because I tell you, as a pro se litigant, you're never going to understand or know every single rule of procedure. I don't care how much you study them. There are lawyers who don't know every single rule of procedure. civil procedure in any court, let alone family court. So you want the judge to give you a pass here and there, but they might choose to or not based on how they classified you. What kind of litigant are you in front of them? Do you deserve a pass? Do they want to make an example out of you? Do they want to teach you a lesson by giving you or not giving you a pass, sticking the rules of procedure to you on a strict basis or not? And then your credibility. Your credibility, which I mentioned briefly, is huge. The credibility the judge gives you based on how they classify you is huge. The judge is not necessarily going to give you the time or the patience or the attention in your documents, but they're not necessarily going to believe your version, your narrative of what happened or what's to come. They're not. Some of this is just human nature. So two people can present the same facts and they can receive completely different responses based on just how the court has classified them. So now that you know that, you know why, you know what the labels are, and you know how it affects the outcome, how it affects the process, your experience. Do you know what you do to accidentally put yourselves in the wrong category? Classification will change before the same judge on a different day. It is possible. I've seen that happen. And let me just tell you, I've had discussions off the record with judges a lot. And a lot of those conversations were about what we considered you, how we viewed you. Judges will have off the record conversations right before you come into the courtroom and will say, they would say it to me and to the other key players in the courtroom. Oh, I didn't remember this litigant until I saw my notes from the last time. They are emotional, so I have to be, or we have to be, or I have to do this, or I have to keep this in mind, or I'm going to do this, or I'm going to treat them this way. It happens. That's real. That's not imaginary. That is real. So based on that, you have the opportunity to change that. If you get some sort of inkling that the judge is viewing you as the emotional or reactive litigant, and you just happen to have a bad day or bad few days the last few times you were before the judge, and you want the judge to see the real you, the poised you, the confident you, the prepared you, then you may go and do a little meditation or visualization or whatever technique works for you. And you may change your classification. But how about if it is the reverse? How about you've always been that prepared litigant, that organized litigant, and this particular day you just happen to have a bad day, and nothing you say or do in the courtroom is going to get the judge to see you as that poised, prepared litigant you were before, because you had a bad day. Especially if the other party knows your triggers and they just happen to trigger you that day. All the other days you managed to ignore them or keep things in perspective or do your woosah and it worked. But today, for some reason, it just didn't. And you're now before the judge and you're seen as that reactive litigant. Well, there's other things people do, a lot of litigants do. They over-explain irrelevant facts. What does that make you? Is that reactive? Is that what? Confident? Is that emotional? How about filing too much, too little? That sounds reactive. How about being inconsistent in your tone? Going up and down and in and out because you're reacting or you're affected by something that has nothing to do with the substance or the merits of your case. How about reacting? You're telling a story, you're telling your side of the story, And instead of telling the timeline or telling the facts in sequence or speaking from a neutral perspective, you're interjecting a lot of sidebars about how you reacted or how you responded or what you noticed or what you witnessed from yourself or the other party or your children. How about coming to court and trying to convince the court that the issue or the petition or the motion that you file is urgent and you need the judge to address it right now and to ignore everything else before it because this is pressing, it's immediate, it needs immediate attention. These are typical behaviors that I see litigants do all the time and they justify it. But from the court's perspective, these are more than likely to get you labeled, classified as reactive or emotional. Yeah, the most that the judge is not really a fan of. So, can you fix it though, once you have been mislabeled? It depends. Of course, if you're working with me, this is one of the things I actually work on when I work with my clients on a 4, 12, or 24-week basis. One of the major things we focus on is how to present, how to position, how to show up in court. Because it's not just about the filings, it's not just about your testimony, it's not just about your proof or your evidence. A lot of it has to do with the way you present, the way you show up in court. Because if you're in court and that's the first thing or the only thing the judge gets to see is the way you present, the judge is going to make a decision or a ruling based on just that. So that is incredibly important to me when I work with people, because being strategic is not just organizing your evidence, accumulating and amassing tons and tons of video and text messages and emails and screenshots. Because if the judge doesn't find you credible, if the judge thinks you're reactive or emotional, they're probably not going to see that anyway. They're going to find a way to impose some procedural rule that limits what you can present to the court. So it's incredibly important to me as a strategist when I'm working with people that they understand strategy is not just about evidence or proof. It's not just about testimony. It's not just about the petitions or the motions and the timing of them. Those are key, but it's not the complete picture. The way you show up in court, the way you're classified, the way you're perceived is just as important. So if you are not confident that you can focus on that or you can get an understanding of that, then yes, it's time for us to work together. And I've seen people do a 180 when it comes to that. I've walked people, I've prepped people, I've role played with people so that they could actually get better at that. Some people are just not in the headspace. It depends on where you are in your case and in the grief cycle. It depends on where you are as far as recovery from trauma. If you are in an abusive relationship with the other party, there's so many factors. But if you're at the point where you've been in your case, you've been entrenched in litigation, and nothing seems to work in your favor, but you are a good person, you are telling the truth, you are doing everything you're supposed to be doing, and nothing seems to work in your favor, chances are the judge has labeled you, classified you, and it's wrong, but it's right in their eyes. There's a disconnect, a miscommunication, misunderstanding, a mismatch you need to work on. So if that is you, you need to listen to the full podcast episode today. When you're done, make an appointment for a strategy session. A 1-hour strategy session, we'll get to it. I will identify exactly what it is that the judge is seeing or hearing. I have a special knack for doing just that. So anyway, that's all I have for you today. I hope this was helpful for somebody you particularly. If you know of a person or 5 people who could use the insight from today's episode, please send them the link. Check out the show notes to set up the strategy session if you want to talk about the label or the classification that you think your judge or the other key players have of you. And let's get to it. Let's get to work. Until next time, take care.
If you're having an active family court case and something already feels off, you need to identify where your case is seriously exposed. Schedule a strategy session now so we can shield your case from more damage. You can't afford to keep guessing. It's costing you way too much.